The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacks voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. I have the great pleasure to be joined today by two terrific lawyers and advocates, the Attorney General from my home state, Peter Neronha, who not only is the Attorney General, but previously was the United States Attorney for Rhode Island, and Attorney General William Tong from Connecticut, who had a terrific education thanks to his time at Brown University, and still visits Rhode Island from time to time. So it's terrific to have you both on. I'm really grateful that you're sparing me the time in your very, very busy days.
Thank you, Senator.
So what I would like to do is jump right into the case that you filed together that affects Rhode Island a lot, but it's also indicative of a lot about the Trump administration, about its behavior, and about its lawyering. And that is your response to the stop work order that was dropped very suddenly onto the Revolution Wind offshore wind project. For people who aren't familiar with that, what's this kind of simple background that led up to you feeling you had to file a complaint?
The first thing to know about this project was when the stop work order issued out of the blue, the project was 80% complete. So of the several hundred turbines, and all the foundations, for example, for the turbines were in, many of the turbines themselves were in, many of the landfall interconnections were done. And so this was not a project that was, drawn up on a chart, somebody's engineering office. This was a lot of time and money and infrastructure invested, existing jobs affected when this stop work order issued.
Workers were actually dressed for work in their gear to go out to the wind turbines and get up there and do the difficult, challenging work that's required. And on their way there, they got the sudden notice and had to turn around, correct? It was that abrupt.
It was. And these were workers who were not only going to work that day, Senator, they'd been going to work out there for months, working in difficult conditions and using highly technical equipment. Does not begin to describe the unique kinds of machines, cranes, floating work decks that are used in this project. And so the president, through his agency, in his stop work order, gave no reason at all for the stop work order. The energy that these wind turbines will produce when finished, and we're confident, I don't want to speak for William, but I know we're both confident that in the end they will be finished since we've turned the work back on. It would service hundreds of thousands of homes, provide electricity, clean, reliable electricity for hundreds of thousands of homes in Connecticut and Rhode Island.
Not only clean and reliable energy, but you made a particular point, both of you, attorneys general, in your case to plead the fact that it would be less expensive, that it would reduce consumer costs considerably by millions of dollars.
That's true, and it's because it's predictable and reliable, which is what the grid operator, separate and apart from us, said independently, that the reliability of this energy was necessary for the reliability of our overall power grid. So clearly the stakes were high. The president's actions from our point of view were unlawful, if for no other reason, that there was no reasoning given for the decision. And under the law, the Administrative Procedures Act and other elements of the law, including those specific to these kinds of projects, before you can stop work in this fashion, you have to give a reason. There was no reason given. And so two lawsuits were filed, one by the company itself in Washington. But I felt very strongly that since Rhode Islanders and the people of Connecticut were going to be affected directly, and that the states had their own interests. We needed to file our own case that we could control in one of our states, and in the end, we chose Rhode Island.
Yeah, let me give some additional context and take a step back to why we need this project in the first place. In many ways, Rhode Island and Connecticut are in the same boat. I am sure that in Rhode Island and in Connecticut, the rates are too high. And the way to drive down rates and bend the cost curve long-term is to bring on more generation, right? The more making of power. We don't have enough generation. We in Connecticut rely on one nuclear power plant close to the Rhode Island border for half of our power at Millstone, 50%. And I'm sure that Rhode Island also relies on Millstone for a big portion of its power. And so we need more sources of generation. And as Peter said, 80% done, $4 billion in. This was going to come online and will come online and provide power to 350,000 homes or more. Here's the other thing to keep in mind about this. This is not the kind of thing where it's like a home improvement project that we do. You work on it at home, you stop, you put your tools down, you can come back to it in a couple weeks, no big deal. For a project of this size and scale, there is a schedule. You have to stick to that schedule because of weather, because of the availability of the boats, because of the ability of the workers, because of how much effort it takes to install this huge heavy machinery. And if you miss that window, you may never get it back, which is why Peter and I had to act as fast as we could in order to capture that window and not lose time for fear that we would never get the opportunity to pick it up again and complete the project.
So let me go back to the point I made about your allegation that this would be less expensive. What was interesting to me about that was that you are under, as lawyers, fairly powerful strictures that something that you plead in court has to be true. You have to have the reasonable, actual belief that what you're saying is true. And at the same time, you've got three cabinet secretaries, the Secretary of the Interior, the EPA administrator, and the Secretary of Energy, all out there in non-sworn environments where they can say whatever they please, just spouting to the world that clean energy is more expensive, clean energy is a luxury we can't afford, to lower costs we have to go back to fossil fuel, and none of that is true. And you having pled that puts that fact into contest in Rhode Island. So I'm really interested in watching the outcome as they come to Rhode Island and develop a more robust response than the answer that they filed.
Well, don't take our word for it. Look at the record in the permitting process. The reason Peter mentioned why this is unlawful, it's unlawful because there's no mechanism for the president to stop work on a project like this. There's no mechanism under the law, number one. And number two is this project has been fully vetted and permitted. So all these questions about science, cost, reliability, national security concerns, environment, all that's been addressed 100 different ways. And that's why this project needs to move forward, because it is ready to go. It is ready to be completed. It has been fully vetted, and there's no basis under law to stop it.
So here's another fact that you pled in the complaint and that the developer Ørsted pled in its own complaint in the District of Columbia lawsuit. And that is that previous to the stop work order, this administration had been in court defending this very project against the allegations that the permits hadn't been properly issued and that there were flaws in the permits and all of that. So when, as I describe it, Moscow Central sent the command that the stop work order had to be issued, in the ordinary course, somebody would send the word back up the chain, hey guys, this might not be your best case. We've actually been in this courthouse on this project as your lawyers making the exact opposite argument that you're now expecting us to make. Are you sure you want us to do this? And it's a signal to me of how sort of brutally stupid the Trump administration can be in terms of not checking the ground for that kind of feedback before they step into something like this stop work order. Isn't that kind of basic due diligence that you would expect if the shoes were reversed would have been done before the stop work order was dropped?
Yeah, look, I think this is a classic case where the client here, the president, is ignoring sound legal advice and just really shooting from the hip. Something set him off, and things set this president off, and something in particular about this project got his attention, whether it be the owner or, the project had a meeting with someone he didn't like, or something, something as de minimis as that in the context of real world legal matters. And he got poor advice, and that's not unique to this case. In the case involving education funding last summer, president was going to stop education funding at the drop of a hat at the end of July. And once we sued him, his lawyers convinced him that reversing course was smarter than trying to overturn the orders that we had requiring him to change course. The president shoots first and asks questions later. And, people often talk about how many lawsuits the AGs have brought. Well, we're not just bringing them because we don't like the president. William has made this point, I think, very eloquently. We bring them because the president has violated the law. He's impacted the residents of our states, our collective states, and we have standing to sue him. And Revolution Wind is just another example of that.
The situation right now is that the D.C. federal court has ordered that the stop work order be lifted and that everybody allowed to go back to work. That, I believe, has been appealed, but with no particular urgency compared to the rush that often characterizes Trump administration bullying legal efforts. And up in Rhode Island, they filed what seemed to me to be a fairly mild answer and have not pursued any aggressive or extraordinary measures. Just to me, it looks like they took a hell of a pasting in the D.C. federal court. They took a look at your very thorough, well-pled, affidavit-supported pleadings, and it looks like they've backed down quite a lot. I mean, they haven't walked away, but this doesn't seem to be pursued right now with the vehemence that often characterizes Trump's litigation.
Well, they took a pasting, but it's not the first time, right, Peter? Peter mentioned the education funding case. That was related to ESSA funding, or ESSA, local education grants, billions of dollars. And, in many of these cases, we've been successful, especially in the lower courts and the appellate courts, because we have them on all fours, as we lawyers say. They don't have a good legal basis. And Peter said, that maybe the president ignored sound legal advice. I question whether he's getting sound legal advice to ignore, number one, right? You've got people like Lindsay Halligan running the show. And so either they're not getting good advice at all or not doing the analysis, or number two, they just don't care. And frankly, probably stronger language than that. They just don't give a flip. And so they're just moving forward with the term, as the three of us know, is arbitrary and capricious. They're moving so capriciously, right? When they feel like it, they do it. Consequences be damned.
And it seems that many of these litigators, or the people who are directing the litigators into court, believe that they have an audience of one. This is all about sucking up to the president and assuaging his petulance and his frustrations. But when lawyers appear in court, they may feel they have an audience of one, but somebody else is watching too. And that's the judge in the room. And it seems to me that the audience of one madness of the administration lawyers is rapidly eroding their credibility in federal courts, not just here, but around the country.
Yeah, Sheldon, I totally agree. As you know, we're involved in litigation involving SNAP funding. The attorneys general have filed a lawsuit in Massachusetts. Some nonprofits and municipalities have filed a lawsuit in Rhode Island. In both cases, judges have responded favorably to the arguments that the president cannot lawfully cut off SNAP funding. I saw a photograph of the group that brought the case in Rhode Island on behalf of those nonprofits. And standing there were two former assistant United States attorneys who left the U.S. Attorney's Office in Providence to go bring litigation against the Trump administration. To me, that is a symbol of lawyers who care, lawyers who understand their obligation of candor to the court, who understand their ethical obligations, and just don't feel that they can do that representing the administration and have gone so far as to take on the righteous causes of suing the administration when it breaks the law. And I think that's why we see some of the lawyering, which frankly is not of the caliber that I saw when I was in the Department of Justice, because when you're literally, as William already alluded to, taking somebody off the street, making them the U.S. attorney in the Eastern District of Virginia, one of the, I believe, two most significant offices in the entire U.S. attorney community, that's a big job, the EDVA.
Second
as
to
you
Rhode
know,
Island,
Sheldon.
you mean?
Well, I was thinking SDNY, but or maybe Rhode Island might
Got
be
to
a
stick
third.
up for the home team here.
Yeah, of course. But this is who the president's putting in charge, and those leaders don't inspire others to follow. We're seeing an exodus from the Justice Department. I think we're going to continue to see that, and I don't think the replacement attorneys are going to be anywhere near the caliber of the ones that they're losing. And then in the end, in the long run, there's going to be a real need to fix that department.
Well, Sheldon, I would say DRI has become extremely important in the past 9 months. And
Yes.
there's a lot of action in Rhode Island federal court. Let me add also that you've mentioned this audience of one. And yes, I, of course, agree there's an audience of one. In the case of Revolution Wind, I think the audience was bigger. I think the people watching were the executives and the shareholders of the fossil fuel companies. That was the audience. And that is why this decision to try to stop work on this project that we all want, all need, is almost done, is so utterly corrupt, because it's about their priorities, the fossil fuel companies, and how we are increasingly living in a kleptocracy, right? Where the instruments of government are used to serve the financial interests of either the president or his friends. And that's why we were compelled to take action too.
And not workers. I mean, we come back to this, how many men and women were going out on those ships, as you already alluded to, Sheldon, ready to work, and how many of them were sidelined, and how many were laid off, and some, because of the delay, will not get their jobs back because the window, as William alluded to, the time frame by which to do some of this work with winter coming has passed. So the president claims to be a friend of workers. And I think many workers believe he is their friend, but his actions are much louder than his words on that score. And he is not a friend to everyday Americans. And I think we're seeing that over and over and over and over and over again.
And to flesh out William's point, in our region of the country, every single day that you can delay Revolution Wind putting its clean, less expensive electrons onto the grid is an added day that those electrons get produced by fossil fuel, with its attendant greater expense and greater pollution, but the money moves to the pockets of the fossil fuel barons who have funded this president.
No
That's
question.
exactly right. Barons they are.
So both of you run offices that are in court all the time. And, William, you're in the Connecticut courts. Peter, you're in the Rhode Island courts. What is the value to your offices of having your courts, your judiciary, trust your judgment, trust your prosecutors, and be willing to give you the benefit of the doubt because they know that you will bend over backwards to tell the truth and only make sound arguments?
Well, Sheldon, going back to my assistant U.S. attorney days, we were taught that when we went over to court, the court should be able to rely on us for giving a good faith, honest, smart assessment of the law and the facts. And we should never stray from that. And I think when you're representing the public, that's your North Star. Your credibility with the court will come back to you to help you in a good case after you've been candid with the court where your case has weaknesses and you are upfront and honest about that. It's incredibly important. And it was incredibly important for me to bring this case in Rhode Island or Connecticut. Either one would have been fine with me. Because our people are the ones directly affected. I don't like being inside the Beltway when it comes to litigation involving everyday Rhode Islanders. I wanted to be in Rhode Island or in Connecticut. That was part of it. It was sort of the atmospherics of it, but also to be in front of judges that have seen the work of the lawyers. And as you said, we have a certain reserve of credibility that we have built up. And I think that's why we've had such success. As William mentioned, we filed 12 cases against the Trump administration in Rhode Island, many of them involving funding, $651 million worth of funding that Rhode Island has gotten and some red states haven't gotten, for example. And we've won all the ones that have been decided in the district court and in the appellate court. We've won 10 out of 12. And the other two are awaiting decisions. And I think the reason we've won them is, as William already said, we understand the law. We're telling it like it is. The president has violated the law. He's harming Rhode Islanders. And we, as the state, have standing to do something about it.
What I always try to remind myself and my assistant attorneys general, and I know Peter feels the same way, when I step into court, when one of us steps into court, I'm not William Tong, and that's not Peter Neronha. It's the state of Connecticut and the state of Rhode Island. And we speak for or representing the sovereign states and sovereign people of our states. And that credibility is incredibly important, number one, because you're speaking for a people, an institution, a sovereign, and the sovereign sometimes and the state is sometimes on the wrong end of a tough case. And, Peter and I are privileged to be on offense a lot, but sometimes the state's on defense. That's not a secret. And it is really important that our word as the state, as the sovereign, it has credibility, has weight, is to be believed and trusted, because very often we have to make tough arguments and prove a tough case in order to protect the state and taxpayers and the public.
So I've been keeping a tally of some of the stuff that I've been reading that judges have said in court, in decisions about Trump administration lawyers. They've described their arguments as disingenuous. They've described their arguments as made in bad faith. They've talked about a concerted government effort to smear and impugn individual judges. They've talked about work as shoddy. They've warned the government that it's losing credibility or sacrificing its credibility. They've accused lawyers of being disrespectful. They've said that they've lied. They've described their arguments as sham arguments, and they've talked about willful and intentional noncompliance, willful disregard of a court order. They've called arguments pretexts, not real, and they've described the conduct of the government as unconscionable. If any one of those things had been said about one of your lawyers in court by a judge, what would the office response have been? Would they just have let that blow by, or would you have stepped up to make a little inquiry about what the hell happened in that case?
Well, for certain, Sheldon, and there would have been a disciplinary complaint filed by the judge with one of our lawyers. Look, when I took over as U.S. attorney, there were some disciplinary complaints that had been made by federal judges to the Department of Justice, confidentially, of course, that I had to deal with, as U.S. attorney. And I was fortunate, and those assistant U.S. attorneys were fortunate that those complaints ultimately were resolved in their favor. But the notion that there isn't a consequence for that from the court itself.
I mean, when judges use those language, they're not just talking to that one judge. They're sending a signal to the organization. Yes. This is a warning, fellas.
Well, yes, and they're also being sent, to the extent one still exists in the Department of Justice, the Internal Disciplinary Council. And those things were taken very seriously. The problem with this administration is that when the president has become detethered from truth, as he has been since he ran for president, however many years ago, his first run. I mean, it's the first time, I think, in our history that the president so openly makes truth something that we don't expect from him or hold him to account for, that it shouldn't come as a surprise that the people that are willing to do his bidding in court or are put in these impossible positions of trying to do it either tie themselves up in knots in such a way that they run into a problem with the court, or are, perfectly willing to do the bidding, as Ms. Halligan is in, for example, in EDVA. So, yeah, I'd be doing an internal investigation, and there's no doubt in my mind, in an ordinary course of the world, there would be an internal DOJ response, and perhaps one from whatever bar, state bar, governs that particular attorney.
And I would also say the buck stops with Peter and it stops with me. I wonder if it stops with General Bondi in the United States Department of Justice, because every pleading, every response, every court filing bears my name. And let's just be candid. I can't have seen every piece of paper. And that, of course, is true. But every time something goes out, it's under my approval.
And that's why you put systems in place to control for this stuff.
Correct.
It becomes automatic that you have to do this because you are responsible.
Yeah.
Right. Like,
so you
exactly.
go in, a Connecticut judge publicly says those kind of things about one of your lawyers or prosecutors. Attorney General Tong, what's your response to that kind of thing? What would the office do?
Immediate call to the Deputy Attorney General, immediate call to the section chief and the division chief. And as Peter said, you're quickly into a process. And if there's a good faith reason for us to believe that what was said was accurate and that somebody engaged in misconduct, then a disciplinary proceeding. And it moves fast. It moves quick because the credibility of the office is on the line. And I said again, selfishly, my credibility is on the line.
Yeah, look, it hasn't happened as Attorney General, for which I'm grateful. But there were times as U.S. Attorney when the chief judge of the district court reached out about the performance of a particular AUSA, or it got back to me that they had made a statement on the record that was of concern to me. And, I not just made a phone call, I arranged a time to come over and have a conversation. I think
there's
you have to
follow-up,
take
for
that
sure.
serious. Well, yeah, for sure.
You can't ignore that stuff. So one last tale. Kash Patel came into the Judiciary Committee and was asked about us getting access to his testimony in the grand jury in the Mar-a-Lago case, where he was a witness after he asserted his Fifth Amendment rights against self-incrimination and was then immunized and then testified. So we asked him about that, and he said from the witness chair in the Judiciary Committee that he couldn't answer that question because he was barred by a court order from testifying about that. He challenged me. He said, "Do you want me to violate a court order?" And he specifically mentioned the chief judge of the D.C. District Court by title. So turns out within a few weeks, that chief judge has the ability to make a decision in a related civil matter. And he puts into his decision, there was no court order. Director Patel was free, as any grand jury witness is, to testify at length about his grand jury testimony. So here's a situation in which the head of the FBI has gone into a public forum and said something involving a federal judge. The judge has now on the record rebutted and said, it's not true. You guys are prosecutors. Is that same concern valid with respect to an investigative agency like the FBI, that once the director of the FBI is believed by the chief judge of the district court to be untruthful, what are the effects that follow from that?
Well, it's the law enforcement agency that most Americans over the years have relied on to be a professional agency that gives them the straight facts. Like anything that this administration does. What do you believe? I mean, I've seen Patel, in the Oval Office with all kinds of charts, running around a little bit like a madman, trying to convince us of the effects of some law enforcement operation when who knows what the truth is. And to come before Congress and as a member of the FBI not understand that the only people barred from talking about the grand jury proceedings are the prosecutor, the court reporter, and the grand jurors themselves is remarkable, just remarkable. So unfortunately, the FBI has a credibility problem with Mr. Patel at the top. And as it does, I believe, with Pam Bondi at the top of the Justice Department, as it does with Donald Trump at the top of the overall government. The people of this country are not well served. My hope is that that will dawn on the majority of Americans, and eventually we will have change.
It's not just a credibility issue of the singular federal law enforcement agency that all of us have come to rely on, but it's the rank and competence that Director Patel has demonstrated in criminal investigations so far of great national import, and living in the shadow or really a stone's throw from ground zero. I was fortunate. I was on a train to New York City on that day and it got turned around. My wife was already in the city, but we hope and pray that something like 9/11 would never happen again. But if and when there is another terror attack on Connecticut or on the United States and people in Connecticut are impacted, what will we do when the FBI has been gutted and is not able to discharge its duties? What will the American people do?
And of course, as we wrap up, the final mischief here is that these statements by Kash Patel, the director of the FBI, to the Judiciary Committee that were not factually true were happening in the same time frame that the Department of Justice was prosecuting a former director of the FBI for coming to the Judiciary Committee and saying things that it alleges were not factually true. You'd think that there'd be some sense of irony or, caution about being extra truthful in those circumstances, but not with this crowd. Well, thank you both very much. It's a real pleasure for me as a former Attorney General to have two real crackerjack attorneys general here who have done great work for Connecticut and Rhode Island. Thank you for joining me on Making the Case.
Thanks,
Thank you,
Sheldon.
Senator.